Good evening, everyone. We're going to have a talk about why the Constitution allows me, a naturalized citizen, an immigrant, to become president.
Let's address the elephant in the room. Article 2, Section 1, naturalized versus natural born. So how can you run for president being an immigrant?
People have been told that you have to be a natural born citizen to run and become president. Legal scholars have already talked about this. It is unconstitutional to not allow me, an immigrant who became a naturalized citizen, to not become president. It's just a matter of law. The only question is, are people aware of this? So let's begin this educational process. What is Article 2, Section 1?
No person except a natural born citizen or citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States.
So that lays out the qualifications of the presidency. So let's start with that. The Constitution is a living document. The articles existed, and then when the Bill of Rights came, the first 10 amendments would overrule some of the articles. And then as new amendments came, they would overrule other amendments. So you're building a foundation, and new things that come are more relevant and supersede things before. For example, the Constitution clearly says only men can become president. That's been changed. So that's a very fundamental thing. Can a woman become president?
Absolutely. It's her right as a citizen.
But there's been amendments that have come after. Women can vote, etc. Do we still have slavery even though certain documents didn't recognize Black people? No, because the Constitution, the Equal Protection Clause, and other things changed that. So we don't have slavery. The broad stroke overview is the Constitution has changed, particularly with the 5th and 14th Amendments, Equal Protection Clause, which has made it amply clear you can't discriminate between citizens. Naturalized or natural born cannot be treated differently. That would be violation of the Equal Protection Clause. So anyone who tries to stop me and says I cannot run for president or be president doesn't know the Constitution. And in fact, if the states stop us from getting on the ballot, they're going to get a massive lawsuit. It's violation of the Constitution. It's unconstitutional, period. A lot of people don't know that the Marquis de Lafayette, who was a Frenchman, never even applied for citizenship, was declared a natural born citizen in the Maryland state legislature, and all of his heirs, so they don't even have to be born here. So all of the Marquis de Lafayette's heirs are natural born citizens. The term natural born has never been defined, just to give you an idea.
Have you filed your paperwork with the FEC to announce your candidacy for president?
The FEC is the agency in the government which manages all federal elections. Now, if I could not run for president, the FEC would not accept my papers. Not only have I filed, but I filled in the FEC 1 form, which has been accepted, and the FEC 2 form. Those are the two important forms. One says I'm running as a candidate, and one says I have my committee set up, SHIVA for president, and I can receive donations. And the FEC has already ruled on this. In 2011, Abdul Karim Hassan, he wasn't permitted based on this issue in New Hampshire. The New Hampshire Secretary of State said they will not accept a filing from any person who's not a natural born citizen. So we want to avoid this because Hassan didn't argue this. However, very important to remember, in that case, the FEC, it came after that filing, and Hassan was essentially trying to get federal matching funds. He wasn't really fighting on this point. The FEC brought its expertise into the question and issued an advisory opinion that the law certainly permits him to run for president and to collect funds, but a different law prohibits from receiving federal matching funds. Thus, there is no constitutional legal bar to run for president. So the FEC has already ruled that I can run for president, period. I'm very serious about running for president because we want to give people a real choice better than the lesser of two evils, Tweedledee and Tweedledum from the Democrats and Republicans. So yes, I have filed my papers. It's legal. You can donate to our campaign, and please do so because you don't want to support the lesser of two demons.
Is there potential for the states to get in the way at the state level? You said you preemptively filed a federal lawsuit, and so I was wondering if you could break that down.
Yes. So first of all, remember the United States is a republic. You have the federal government, and the states are the ones at the local state level. They have the rights to administer the elections, what kind of machines they use, if they're going to do mail-in ballots or non-mail-in ballots, etc. So how do you get on the ballot? Every state has different rules. Some states say, like Vermont, you have to get 1,000 signatures, which means people have to say, hey, I want this guy to run for office. Other states like Florida have a rule. It's a certain percentage of how many people voted in the last governor race. It could be like 100,000 signatures you have to get, and so on. Bottom line is every state has a different rule to get on the ballot. Who administers this is called the Secretaries of State. So for me to get on the ballot or for you to get on the ballot, you have to go to every state and you have to follow their process. Now, some some of the state legislatures may be ignorant. They may construe just Article 2, Section 1. They don't know the amendments existed. Because remember, a lot of people are dumb about the law. Arnold Schwarzenegger is dumb about the law. He can actually run and be president. He has very bad lawyers. But the point is, secretaries of state are likely ignorant of this, even though it's clearly constitutional. We want to make sure that when we collect our signatures and you walk into the secretaries, they say, oh, he's not a natural born citizen, Chris. We don't want to wait until then. We're proactive. So that's why, in order to preempt that, we want the Attorney General of the United States to notify all the Secretary of State, yes, Dr. Shiva can run for office. It's called a declaratory relief. We want him right now to tell all the Secretaries of State, you cannot stop when Chris Bradley comes in and wants to put Dr. Shiva on the ballot, or you can't stop Teresa Rosen in Massachusetts when she wants to put Dr. Shiva on the ballot. If you do, you're violating the law and it's unconstitutional. And the reason we want to do this is we don't want to be screwed. We don't want to be in some litigation in 2024. We want to do that now. So that's why we have filed. And again, I'm representing myself because lawyers always screw things up, as we saw in Massachusetts, because it's easy to buy them off. They don't really want to go against the government. So I'm an immigrant, naturalized citizen. I'm seeking a judgment that we want Merrick Garland to openly tell all the secretaries of state, hey, he's eligible to serve as president in spite of the Article 2, Section 1. The duties of the Attorney General include issuing authoritative opinions regarding the meaning of the U.S. Constitution and protecting the civil rights of citizens. This is really a civil rights lawsuit. No different than Black people being allowed to go into public schools, even though the racists try to keep them out. The first thing we're asking the court to do is declaratory and injunctive relief that plaintiff has a First Amendment right to run for office regardless of quote unquote qualification. The First Amendment, once you're a citizen, gives you the right to run for any office regardless of qualification. This is very important to remember. In fact, imposing qualifications like to hand out a flyer or leaflet and even run for office at a base level is violation of the First Amendment. So the First Amendment itself supersedes Article 2, Section 1.
There is no provision of federal law that prohibits a naturalized citizen from running for president, regardless of whether or not that person could ultimately serve as president if elected.
And the next thing that the FEC further determined that a naturalized citizen was fully entitled under federal law to solicit campaign funds. I'm not violating the law by saying donate to the campaign. Neither are you. And the next thing is
presumptively entitled to deference by this court as the FEC was issuing an official opinion in its area of expertise.
What does that mean? One of the areas of law is that the courts will always defer to an expert, like an agency. So we're saying, look, the FEC has already ruled that I can run for president. Now I want to talk about the 5th and 14th Amendments. 5th and 14th Amendments are central to this. The Equal Protection Clause of the 14th Amendment states, quote, no state shall deny to any person within its jurisdiction the equal protection of the laws.
The 14th Amendment prohibits states from discriminating against citizens based on national origin or on status as a naturalized versus a natural born citizen.
So this has been already adjudicated over the last 100 years. The 14th Amendment prohibits states from discriminating against citizens based on national origin. That means a citizen is a citizen. You cannot have second-class citizens. In fact, here are the big cases on McDonald versus City of Chicago in 2010. Clearly says that it irreconcilable with the principles of equality, government by consent, and inalienable rights proclaimed by the Declaration of Independence and embedded in our constitutional structure. So that was a very major court ruling which said you cannot have two classes of citizens. Second is Ayyadurai versus Pena in 1995, reiterating distinctions between citizens solely based on their ancestry are by their very nature odious, which means awful. To free people whose institutions are founded on the doctrine of equality. That's the 14th Amendment. So again, people aren't studying history. So Article 2, Section 1 of the Constitution is repealed and abrogated by this. It's overwritten. Accordingly, insofar as any state might attempt to deny ballot access to certain individuals based on national origin. Chris, when you go try to submit the ballot signature to Indiana, and I'm preparing you for this, Chris, and the Secretary of State says, oh, that guy is a naturalized citizen. That's like saying, would be like in the 1700s, oh, you're Black. You don't have voting right access. That's the same thing. But now we have these amendments that were passed. This constitutes invidious and illegal discrimination. So it's illegal, everyone. If they stop me, and I followed all the rules, Chris, to get on the ballot, and they stop me, that is illegal. And Chris, you and I can become plaintiffs in Indiana if they do that. Remember, the 14th Amendment is at the state level. The 5th Amendment requires the federal government to provide equal protection for all in the same way as the 14th Amendment of equal protection applies to the state. And this was a very important ruling in Bowling versus Sharp. The 5th Amendment, after Bowling versus Sharp, incorporated the 14th Amendment. So 14th Amendment says within any state, you have the equal protection of citizens. After Bowling versus Sharp in 19 1954, the 14th Amendment essentially gets incorporated into the 5th Amendment because the 5th Amendment's at the federal level. So we're saying at the state level, they can't discriminate me, and also at the federal level, Chris. Accordingly, pursuant to the requirements of the 14th Amendment, the United States may not discriminate based on national origin as a naturalized citizen. And there's another case law. And in Schneider versus Rusk, the judge ruled discrimination aimed at naturalized citizens, immigrants who went through the process like I did, creates indeed a second-class citizenship that is incompatible with the Fifth Amendment. Moreover, a naturalized citizen, quote, becomes a member of the society, possessing all the rights. Chris, what does all the rights mean?
All of them.
Yeah, that means I can run for president and be president, right? All the rights and standing in view of the Constitution on the foot of a native. One of the most important things in 1967, Afraim versus Rusk. Very plain, which means this abrogates, repeals Article 2, Section 1. And then, therefore, we say, insofar as Article 2, Section 1 might be interpreted to forbid naturalized citizens from being president, such a doctrine is entirely incompatible with the guarantee of equality found in the 5th and 14th Amendments. So again, if you are an American and you believe in the Constitution, the 5th and 14th Amendments repealed Article 2, Section 1. The 14th Amendment is the most significant structural provision adopted since the original framing and has had profound and extensive effect upon the rest of the Constitution. McCreary County, Kentucky versus American Civil Liberties Union in 2005. Think about that. The 14th Amendment is what makes America America today, right? For example, the 14th Amendment permits Congress to authorize suits against the state that were previously prohibited by the 11th Amendment. Fitzpatrick versus Bitzer, the Supreme Court held that the 11th Amendment, the principle of state sovereignty, which it embodies, are necessary limited by the enforcement provision of the 14th Amendment. This was true despite the fact the 14th Amendment did not explicitly mention the 11th. The point is that one amendment can overcome another amendment.
Just because it didn't explicitly mention, it still overrides the previous amendment.
Exactly.
Yeah, I think that's important for everybody to understand.
Right. 45 is a natural-born provision of the Constitution insofar as appears to permit the invidious, which means egregious national origin discrimination, is irreconcilable and is abrogated, which means repealed and implicitly repealed by the Equal Protection Clause, the Citizenship Clause, and the Privileges and Immunity Clause of the 14th Amendment, as well as the Equal Protection Guarantee of the 5th Amendment. Accordingly, any discrimination against presidential candidates by either the states or federal government are unconstitutional and null and void. The final thing, Chris, is that we're also saying that the political process should rule. The entire Constitution, the process was set up to engage people bottoms up, and people forget this. That's, for example, why we have the concept of referendums, right? It's always to bring people into the process, bottoms up movements, and this is what the founders wanted. And our campaign is saying the future is about you. It's not about me running for office. I just happen to be a humble catalyst who has studied system science, understands we need to think beyond left and right, and I educate people. And I want other people to educate people. But the fundamental issue here, this is about building a bottoms-up movement. So change has always come bottoms up. How did the women get the right to vote? Susan B. Anthony begged to the Democrats and they laughed her out. They go, get the hell out of here. What do you mean a woman should be able to vote? By the way, in the 1920s, when women were fighting for the vote, Afghan women already had the right to vote. So just to give you an idea, Susan B. Anthony, the government and the representatives, the politicians laughed. And what did she do? She went and built a bottoms-up movement, the suffragettes, and they went and got signatures. So it's about building a bottoms-up movement. So everything we do is about building a bottoms-up movement. We want to put power back into people. By the way, every Thursdays at 8 p.m., we do a town hall. And you can go sign up for it at vashiva.com/orientation or shivaforpresident.com/town hall, where we're taking every major issue. We're not waiting to get elected. We're teaching people the healthcare solution, which is boost your immune system. We're teaching people education, which is learn the science of systems. So we're already doing the work of a president. In many ways, I'm running as a president in exile. You could talk about it. And our movement is here. But part of this notion of the political process, we put this in our lawsuit. Not only do we want Merrick Garland to educate all these secretary of states, hey, Dr. Shiva can run. It's already been looted by the FEC because he has First Amendment rights. Number two, he's a citizen, and you cannot discriminate between a natural born and native born. It's already been decided 100 years ago by the 14th Amendment. Number three is that let the political process decide. Let the people of the United States decide, the citizenry who can vote. They should decide. So we've given three arguments to Merrick Garland. All three are very strong arguments. So let me show the third argument. Here's the third argument, which says count three, declaratory and injunctive relief, that the qualifications for president is a non-justiciable political issue that is determined by the voters and hence cannot be interfered with state or federal. Non-justiciable means that this should be a political process, even if you don't believe in the other two. So again, we say, although Article 2 discuss qualifications for president, the Constitution does not provide any mechanism for enforcing this provision. Also, nowhere is natural born citizen defined. Point 50 is there's no enforcement mechanism, the qualifications for president appears to be a non-justiciable political issue that is in effect left up to the voters themselves. A controversy, we define, is non-justiciable when it involves a political question and the determination of the issue is vested with the political process. So what we're saying is who runs for office is a political process issue. And there's a very important Nixon versus US case. Now, Article 1 of the Constitution says that no person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States. But further provides that, quote, each house shall be the judge of the elections, returns and qualification of its own members. And see Burton versus US, which said the Senate is made by the Constitution the sole judge of the qualifications of its members. Just as Article provides for qualifications for elected representatives, but leaves it up to the political process to adjudicate these elections. So you see the political process decides the qualifications, Chris. Article 2 also appears to leave the issue to the political process. Therefore, no state or federal executive official should be permitted to refuse to allow a candidate. We're basically saying the secretaries of state, Chris, they're just one person, cannot refuse me to run for office just on this justiciability issue, on an assertion the candidate does not meet the qualifications. So we have three arguments, Chris, three very powerful arguments we put into this historic lawsuit. Number one, First Amendment. Number two, Fifth and 14th Amendment. Number three, it's a non-justiciable issue. There you go. And by the way, if Garland doesn't listen to this and it gets dismissed in the federal court, we'll take it at the appeals court. We'll take this issue all the way up to the Supreme Court. Our campaign is historic for many reasons. By the end of our campaign, every American is going to know a naturalized citizen immigrant can run for and be president. Now that's pretty historic, guys, because there's 22 million hardworking immigrants like myself who contribute a lot to this country. They're naturalized citizens. They're right now being ignorantly discriminated. We fight for America here and now. Everything we do. I am doing this because we have a massive movement that we're building for truth, freedom, and health globally and in the United States. We are a campaign of action. Be well. Thank you.